a county sheriff's deputy rolled up to the Mackey Ranch gate, carrying a lawsuit for $48,000 over a split-rail fence.
Mr. Mackey, you've been served. Meadowcrest Estates, HOA says your fence violates their boundary compliance code.
That atrocity doesn't meet our standards, and it sits on HOA jurisdictional land. You'll pay every cent.
This land has been in my family since before your HOA existed, and this patent says it always will be.
A piece of paper from the 1800s, please. My attorney will shred it.
She doesn't understand. Abraham Lincoln's signature isn't just history, it's federal law.
The 1862 Homestead Act patent granted allodial title under federal supremacy, immune to any later local charter.
Your stubbornness will cost you. The HOA board is prepared to bankrupt you over this.
Great-grandfather cleared this land by hand. I will not let a clipboard bully erase his name.
What Shirley didn't realize was that the document Dennis held didn't just defend a fence, it could void the entire HOA from the start. And now it was heading to federal court. The next morning, Dennis drove into the city and walked into the law offices of Emily Grant, a federal land use specialist.
This is an 1862 federal land patent, signed by Abraham Lincoln. Do you understand what you have, Mr. Mackey?
It means my land was granted by the United States government. No HOA charter can override that.
Exactly. Under the Supremacy Clause, this patent preempts any local ordinance, but the county judge used to represent HOAs. He won't see it that way.
Then we lose at the county level and appeal. I am not settling, not for my grandfather's land.
Emily studied the parchment, already mapping the appeal to federal district court. The patent was their nuclear option.
I'll file a motion to dismiss based on the patent, but be prepared. Shirley Vance will fight dirty when she sees we're serious.
Let her come. This land survived the Civil War. It'll survive her.
That afternoon, Emily filed the motion to dismiss. The county court date was set for 2 weeks later. Dennis returned to his ranch, knowing the first battle would be ugly. But the real war would be waged on a much bigger battlefield. 2 weeks later, the county courtroom filled with the scent of old wood and fresh hostility. Shirley Vance took the stand first, her coral blazer a splash of aggression.
That fence is a blight. It violates HOA standards and sits squarely on land we govern, not some cowboy's fantasy.
Your Honor, this patent is a historical curiosity. It has no bearing on modern land use covenants.
The Supremacy Clause makes this patent federal law. It preempts any local charter, including the HOAs.
The judge's face says it all. He's already decided this is an HOA case, not a federal one.
The county judge banged his gavel, ruling for the HOA and ordering Dennis Mackey to pay the full $48,000.
I told you, Mr. Mackey, your old paper is worthless here. The HOA always wins.
On the courthouse steps, Emily Grant signed a notice of appeal to federal district court before the ink on the order dried.
This was never about county court. The real fight is where that patent speaks loudest.
Shirley had won a battle, but the war was moving to a venue where 1862 weighed more than 1987, and Abraham Lincoln might yet have the last word. 9 days later, the federal district court accepted the appeal. Judge Leonard Morrison, a silver-haired jurist known for constitutional rigor, set an expedited hearing.
Mr. Finch, your client's charter cannot simply ignore an 1862 federal patent. Full discovery on the HOA's 1987 incorporation is granted.
Your Honor, we specifically request the original meet and bounds description. Something does not align with the patent's recorded survey.
When the incorporation papers arrived, Emily spread them across her conference table beside the 1862 patent. The fatal flaw was immediate.
Dennis, the HOA's charter includes your parcel in its legal boundary. They annexed federal patent land they never had power over.
A 1987 survey map confirmed the blunder. The HOA's jurisdictional line sliced straight through the Mackey homestead, as though the 1862 patent never existed.
They built an entire HOA on a boundary mistake. This isn't just my fence. The whole charter might be void from the start.
Within hours, Emily filed an amended complaint challenging the HOA's charter as void ab initio, null since its inception. Judge Morrison scheduled oral arguments immediately.
Counsel, this court will consider whether the inclusion of patented land voids the entire HOA charter, not merely the fence dispute. Prepare your arguments accordingly.
The fence case had just detonated into an existential threat to the HOA's very existence, and Shirley Vance still had no idea what was heading her way. That night, the HOA board huddled in the community center, dread thickening the air.
We will fight this. That patent is a museum relic, and our lawyers will bury it again.
But the federal judge already questioned our charter. What if we lose everything?
If the charter voids, every fine and assessment could be refunded. We'll be ruined. Settle.
I recommend a nuisance settlement with a non-disclosure agreement. Offer him $10,000.
Before noon the next day, a courier handed Dennis Mackey a thick envelope at his gate.
$10,000 and a gag order, as if they could buy my silence about what they stole.
Dennis tore the offer in half and tossed it on the porch. Within hours, an anonymous complaint summoned a county inspector. The inspector walked the fence line twice, found no violation, and left with an apology. That afternoon, federal agents Keller and Reese walked into the HOA office with subpoenas for every financial record since 1987. 3 days later, federal courtroom arguments began. Harold Finch opened with a proposed fix: amend the charter.
Your Honor, the HOA can simply amend its charter to exclude this disputed parcel. The case becomes moot.
Amendment cannot cure a flaw that voids the charter from its inception. The HOA never had proper jurisdiction.
Mr. Finch, if the charter was flawed from day one, haven't all its fines and covenants been tainted?
We argue the charter is severable. Correcting the boundary doesn't require dissolving the entire HOA.
The charter's geography is its foundation. Remove this parcel, and the community loses its legal basis.
Submit supplemental briefing on whether a void charter voids all prior actions. 10 days.
This rancher is stealing community land. We built those neighborhoods, not him.
Mrs. Vance, one more outburst, and you'll be held in contempt. Control your client, Mr. Finch.
Harold Finch walked out with sweat stains and a loosened tie. The HOA's last legal argument had just collapsed. 10 days later, Judge Morrison reconvened the federal courtroom. The gallery fell silent as he began.
The 1862 patent is supreme. The HOA's 1987 charter illegally included federally patented land and is void as a matter of law. This court now orders supplemental briefing on the retroactive effect. Can 38 years of HOA governance survive a void charter?
We just cracked the door, and behind it is every fine, every covenant, every dollar they ever took.
You are destroying a community. We built homes, parks, roads, and you are sweeping it all away for a yellowed scrap?
Mrs. Vance, sit down now. You are perilously close to contempt.
38 years of bylaws. Void. We'll have to refund everything.
Every assessment we collected will be personally sued. Our insurance won't cover this.
Outside, news vans crowded the curb. The story was already spreading. 1862 patent voids HOA. But the biggest question still hung in the air. Could a void charter undo decades of fines? And who would pay? By dawn, local news blared. 1862 patent voids HOA charter. Homeowners dialed lawyers, demanding decades of dues back. A class action lawyer held a press conference, estimating $74 million in refunds if the charter was void from the start.
Our insurance carrier just denied coverage. They said our acts were beyond any legal authority. We're exposed.
Personal bankruptcy. Our homes. 38 years of service and we'll lose everything.
We can move the liquid assets somewhere safe. Delay, stall, anything to keep them from seizing everything.
Absolutely not. That's concealing assets, a federal felony. I will not go to prison for this.
Judge Morrison scheduled an expedited hearing to consider dissolving the HOA and appointing a federal receiver.
Shirley's empire is crumbling. I didn't want this, but I'll see it through for every family she cheated.
The HOA board sat in stunned silence, voided charter pages scattered before them. There was nothing left to argue. Everything now hinged on Judge Morrison's final order. Would 38 years of HOA governance vanish overnight? The remedy hearing opened in a packed federal courtroom. Homeowners, lawyers, and the entire HOA board sat in tense silence.
Your Honor, this court has already ruled the charter void. The only equitable remedy is dissolution and a federal receiver.
I find that all HOA regulations, fines, and assessments since 1987 are void. The HOA is dissolved effective immediately.
He banged his gavel once. The class action lawyer immediately entered the $74 million refund estimate, filed Exhibit 74. 38 years of unjust enrichment, refundable to every homeowner. The HOA board turned white.
Therefore, we propose Dennis Mackey as temporary federal receiver. He is impartial, has no conflicts, and the community trusts him.
Mr. Mackey, this court would appoint you as receiver. Do you accept the responsibility?
Him? He's the one who destroyed us. He'll loot what's left.
Mrs. Vance, you've been warned. Another word and you'll be removed. Mr. Mackey, your answer.
Every homeowner, every reporter, every federal agent waited. One rancher held the power to return millions or let chaos erupt.
I accept, Your Honor, but I am not keeping a single cent beyond what's fair.
We've calculated a 4% administration fee that covers audit costs and the restoration of your great-grandfather's cabin.
Judge Morrison signed the receivership order, approving the 4% fee and Dennis's plan. The cabin would become a museum. Within a week, Dennis had a makeshift office in the HOA community center, mountains of records surrounding him.
Great-grandfather built a home with an axe. I'll restore it with a 4% fee. Every dollar will be returned minus 4%. Just enough to cover costs and restore my family's original cabin as a museum.
A homeowner stood, voice cracking. Thank you, Mr. Mackey. You could have kept it all, but you didn't.
You are a good man, Mackey.
Shirley thought she could bury me, but all she did was make me custodian of her mess.
That afternoon, Shirley Vance filed an emergency motion to stay the refunds, claiming financial chaos.
Denied. Your motion is frivolous. Mrs. Vance, Mr. Finch, you are cited for contempt. Your personal assets are frozen.
The order froze bank accounts, investment portfolios, and even the Range Rover Shirley used to gloat. Dennis used the 4% fee to hire a team of heritage conservationists. The old homestead cabin would rise again.
Every log in that cabin holds a story. 5 generations. We're going to tell it right.
On a crisp morning, he broke ground beside the crumbling chimney. A replica patent hung on a post, watching over the site. Meanwhile, refund checks began arriving. A retired teacher opened her envelope on the porch, staring at 18 years of wrongfully paid dues. Her daughter hugged her, crying. $32,000. A college fund restored. Local news captured the moment. Shirley watched from her dark living room, her coral blazer hidden in the closet.
Shirley built a kingdom on a lie. I am just giving people back what they earned.
6 months later, the restored cabin stood on the hill, freshly chinked logs catching the afternoon light. A red ribbon stretched across the door.
Great-grandfather raised this cabin with an axe. Today it opens as the Mackey Homestead Museum. The patent that saved this land belongs to history now, and to every family that got their money back.
Your great-grandfather would be proud. Sir, you gave people back their lives.
The final refund checks had been distributed. After the 4% fee, $71,040,000 had been returned. Former HOA homeowners crowded the museum opening, children running on the grass that was once a legal battleground.
You didn't just beat an HOA, Dennis. You set a precedent that will protect federal land patents for generations.
All I wanted was to keep my fence. Now there's a museum and $71 million back where it belongs.
The newspaper called it Ranchers 1862, Patent Creates Museum, Returns Millions. The story spread nationally. For Dennis, The biggest reward was watching families walk through a door that was never theirs to lock. Shirley Vance stood for sentencing in the same federal courtroom where she'd screamed at Dennis 6 months before.
3 years of probation. You are permanently barred from serving on any HOA board. This court will not tolerate malice.
She walked out, shoulders slumped, the coral blazer only a memory. The Range Rover was gone, sold to pay fines. Harold Finch surrendered his law license to the state bar. The disciplinary board cited repeated professional misconduct. The Meadowcrest Estates HOA was formally stricken from county records. An official void seal closed its corporate file. A letter arrived at the Mackey Ranch from the state bar. Thank you for exposing a fraudulent charter that corrupted our profession.
All I did was hold onto a piece of paper. The law did the rest.
The State Historical Society awarded Dennis a preservation citation. The 1862 patent was registered as a National Historic Document. The final newspaper headline read, "Entire HOA erased by 1862 patent. 38 years of governance declared void. The museum stood where the fence once did." And the man who wouldn't pay a lawsuit now collected history. 1 year later, Dennis Mackey sat on his cabin porch, a mug of coffee in hand, the museum silent in the distance.
Great-grandfather never saw this fight, but I think he'd know justice was served.
The 1862 patent hung above the fireplace inside, its faint Lincoln signature still legible.
5 generations on this land, and I nearly lost it over a fence.
The sun dropped behind the prairie, painting the sky in gold and rose.
But I didn't lose it, and because of that, all those families got their money back.
Inside, the patent rested in its glass case, a quiet proof that law can outlast greed.
I am just a rancher who refused to give up, and plenty of people smiled at that.
As darkness settled, Dennis walked to the new gate, closing it with a soft click, and the land finally belonged to no one but him. Some documents don't just record history, they change it. Dennis Mackey's 1862 patent didn't just win a lawsuit. It shattered a system that had stolen millions. A simple split-rail fence became the fault line between a corrupt HOA and the supreme law of the land. In the end, the HOA was erased, $74 million returned, and a museum rose from the ashes. But the real victory was never about money. It was about the idea that a promise made in ink can still hold weight, that a fifth-generation rancher could walk into court with a yellowed page and demand justice, and that Abraham Lincoln's signature, faded but unwavering, could outlast every boardroom scheme. So next time someone tells you that old documents don't matter, remember Dennis Mackey. Remember that the law is older than any HOA, and justice, when you fight for it, still exists. The 1862 patent. Lincoln's name still glowing in faint light. A promise kept. If you've ever faced an unfair fight, an HOA, a bully, a system that said you were nothing, then you already know why this story matters. It's not about a fence or a patent. It's about the truth that old ink can still carry new justice. Dennis Mackey didn't win because he was rich or connected. He won because he refused to fold. He kept every tax receipt, every survey map, every scrap of paper that proved the land was his, and when the moment came, he had the weapon they never expected. The law itself. So check your attic, your safe deposit box. You might have a patent, a deed, a letter, something that can change everything. And if you do, don't let the bastards take what's yours. Thanks for watching. Hit subscribe for more stories about the little guy outsmarting the machine. See you next time. Keep your receipts, all of them, because in the end, the system isn't run by lawyers or judges. It's run by people who refuse to quit. Dennis Mackey stood in a courtroom with nothing but a yellowed page and a lifetime of memories. He didn't need a team of expensive attorneys or a backroom deal. He needed the law to remember what it was built for. So if you are ever told that a document is too old to matter, remember this ranch. Remember that Abraham Lincoln's signature, still legible after 160 years, can still speak louder than any HOA. Justice isn't a convenience. It's a promise. And sometimes it's written in ink that people forgot, so check your attics. Open your safety deposit boxes. The paper you are sitting on could be the next Mackey patent. And when you find it, hold on tight. Because the bastards are always waiting, but so is the law. Thanks for watching. Hit subscribe, and we'll keep bringing you stories that prove the good guys don't always finish last. See you next time. Keep your receipts. All of them. The story of Dennis Mackey and his 1862 patent is proof that history never really stops fighting. $74 million in fines. Erased. An entire HOA dissolved, its charter stamped void by a federal judge, and a 160-year-old signature, Lincoln's own hand, was the legal sledgehammer that did it. Dennis didn't just win back his fence. He reclaimed his family's story and built it into bricks for the next generation. So if you are still wondering whether one person can beat the system, drive past that museum, look at the patent, read the name, and then ask yourself whose side the law is really on. This isn't just a story about a fence. It's a lesson about ownership, legacy, and the quiet power of old ink. Share this story with someone who's being bullied by an HOA, a developer, a title company. Let them know that the biggest weapon isn't money or influence. It's a piece of paper they can't wash away. Thanks for being here. We'll see you in the next one. In the end, Dennis Mackey didn't just win a lawsuit, he reclaimed a piece of American ground that no boardroom could ever own. That 1862 patent turned a simple rancher into the undoing of a $48,000 fraud that had stretched for decades. And when the final gavel fell, it wasn't just a fence that stood, it was a legacy that no HOA could erase. The museum that Dennis built from the administration fee isn't just a tribute to his great-grandfather. It's a permanent reminder that the law can still work for the little guy. Families who once feared losing their homes now stop by to shake Dennis's hand, knowing they owe their savings to a man who refused to bow. This is the story of how a fifth-generation rancher taught an entire HOA that some documents don't expire, they only get stronger. So, if you are facing a bully, a corrupt HOA, or a system that seems rigged, remember this ranch and the piece of paper that saved it. Justice doesn't always come quickly. But when it does, it can arrive in the form of a signature written in 1862. Share this story. Let people know that the law isn't just for the powerful. It's for those who keep their receipts and never stop fighting. From the Mackey Homestead Museum to your own fight, keep your history close, because it might just be the one thing that sets you free. This story isn't fiction. It's proof that the law still has teeth when someone is brave enough to bear them. That faded signature, Lincoln's own hand, wasn't just a historical relic. It was a legal battering ram. And the museum that now stands on that land, it isn't just a building. It's a promise that no HOA can ever rewrite. Dennis Mackey didn't need to be loud. He needed to be right. And with that patent, he was bulletproof. Every hand he shakes at the museum is a family that got their money back, their dignity restored. So the next time someone tells you old paper doesn't matter, remember where the real power lies. It's in the ink that outlasts empires, and in the people who refuse to let their history be erased. This is the Mackey Homestead, 160 years in the making, and now, finally, unbreakable. If you enjoyed this story, hit subscribe and join a community that believes in justice, evidence, and old paper. Thanks for watching. And remember, keep your receipts, all of them. In the quiet of the evening, Dennis Mackey stood at the museum door, looking out at the land his great-grandfather claimed with nothing more than ink and an axe. Inside, the 1862 patent rested in its glass case, Lincoln's signature still catching the last light of day. No HOA sign now marked the entrance. Just a split-rail fence, and history that refused to vanish. Families came and went, but the museum stayed open late on weekends, a quiet monument to ordinary resistance. Dennis didn't give speeches anymore. He just opened the doors and let the story tell itself. The land that was almost stolen was now a classroom, a courtroom, a sanctuary for anyone who needed proof that paper can still win. And in the quiet of the prairie, if you listened, you could almost hear the echo of a judge's gavel and the scratch of a quill. Some fights end in fire. This one ended with a breeze through the tall grass and a name preserved in dry ink. From a fence to a fortune, from a patent to a promise, Dennis Mackey restored more than a cabin. He restored the simple truth that law, when held by honest hands, still belongs to the people. Dennis Mackey still walks the fence line each morning, coffee in hand, the museum a silent promise on the hill. The 1862 patent no longer rests in a drawer. It occupies a climate-controlled case, a national treasure under glass. School children visit on field trips, learning how a simple homesteader's document can still speak louder than any modern charter. Dennis doesn't charge admission to the museum. He says the story, and the justice it represents, is payment enough. Lincoln's signature, still sharp after 160 years, reminds every visitor that the law is older and stronger than any HOA. The split-rail fence that sparked the lawsuit now borders a field of wildflowers, a quiet boundary between past and present. And as the sun sets, Dennis latches the gate. No more lawsuits. No more threats, just the land. If you ever doubt that old documents don't matter, come to the Mackey homestead. The proof is under glass. Justice, like ink, may fade. But with honest hands and a lifetime of receipts, it never disappears. From the Mackey Homestead Museum, where a promise made in 1862 still keeps the gate open. Good night.